जंगल में द्वारा तेरा चला रहे गाड़ियों से आवाज आई कराने चलाने की मैंने देखा तो अपने पास में चली अवस्था में एक व्यक्ति मिला इससे भी पूछा कि आपका नाम क्या है। उसने अपना नाम लक्ष्मी दीन बताया और गाँव का नाम कर इस पर जो है सुरेश सिंह ने इस मंदिर के जनपद सदस्य को फोन पर सूचना दी कि यहाँ पे कल्याणपुर का लक्ष्मी दीन की अवस्था में पड़ा है। इसकी सूचना पर उसने गांव सूचना पहुंचाए। गांव के लोग जब आए जब लोग तो उसके भतीजे अपने जाति जंगल में देख सकते आपकी अवस्था किसने दशा किया उसने एप्लीकेंट राम 300 केस बड़ा था हमारे यस और इसके बाद भी अस्पताल में जाते हैं। अस्पताल में
whether death was in the hospital or he was not dead?
Not dead. They are not dead. Yes, cause of death was solved due to acid burn. Homicidal in nature and this one acid से जलना बताया है। Urgent applicants से कोई Dharmesh, love. ये तू बता।
Kamlesh Lodhi is nephew of the deceased and Rajesh Lodhi is son-in-law.
चरवाहे जितने पहले देखा सबसे पहले चरवाहों ने देखा उससे उनके पूछने पर भी इसने नहीं बताया कि अमुक लोगों ने नीचे मारा। That was the period 12 and 13.
How much was the time between when he was hospitalized?
परीक्षण बताया है कि मेरा 6 hours कहना गलत है कि चित्र की मृत्यु के नाम 24/12 को 2 बजे की सदा करनी छुट्टी के शाम 6-7 बजे की मृत्यु हो जाती है। पता काशी मेरे घर में मृत्यु की अवधि 24 घंटे के अंदर बताएगी।
CD was also prepared.
सीधी वर्क प्रोफेशन इसमें निरीक्षक ने कहा कि वोट चलते दिखाई दे रहे हैं, पर क्या करा ये समझ में नहीं आ रहा।
Who prepared that CD?
तो ये ड्राइवर था जो गाड़ी में गया था उनके साथ।
उनके साथ गया था। ड्राइवर किसका गया था वो?
कोई आया था ड्राइवर,
किसके साथ गया था?
ये जो मतलब वो उन्होंने गए थे पूछना उनके साथ ड्राइवर।
What was the statement of IO in respect of the CD?
जब तक उनका आर्टिकल एक कहता है सारा किसी विभाग की डिसिप्लिन पर लिखा जाए सारी चीजें पास और कोई भी मिनिस्टर के पास आर्टिकल ऐसे में संबोधित जैसे भी क्वालिटी वाला आर्टिकल इस वजह तो मैं किसी परचेस कर रहा हूँ
सीधे रिपोर्ट दी होगी जिसमें वो रेप स्टेट
last seen evidence is there, para 15, and the reason of causing death is at para 20. Secondly, a person at the instance of the acute bottle by which the acid was found.
by whom?
Nothing was found.
Used by whom? Death nobody is denying.
पेश के बताए अनुसार घटना स्थल पर बॉटल according to the memorandum bottle which was discovered, which was supported by the
Last seen by Bhaiyalal Kushwaha. No, Valmiki, TW11. He saw in the evening of 24 September in the shop of Bhaiyalal.
और सिर्फ ये तो जो दिया है पैरा 23 में साक्षी महेश ने कथन किया है कि मृतक ने उसको बताया था 8-10 दिन पहले कि 70,000 रुपए जो है वो अभियुक्त रशीद पटेल उसको दिए थे, पर वो वापस करने में आना नहीं सकता। साक्षी कमलेश ने भी ये बात दोहराई।
Oral time declaration before two persons. One is nephew, second one is son-in-law. CD was also prepared of that very occurrence, where lips were found gasping, but voice was not audible. This is IU saying. What was the oral time declaration? The voice was not audible. Allegations are that he disclosed the involvement of two persons, to nephew and son-in-law.
The station is different, but at the place of incidents, it's
Oral time declaration was made there.
not sure. So let's say each there,
Yes,
place of incident, there his condition would have been different than the condition in the office.
no, the oral time declaration was at the spot where body was there in injured condition.
CD was prepared at
They are only by the driver of the vehicle. When they went there to carry him, took him to the hospital. Nothing was audible. Lip movements were there. What was oral dying declaration then? 90% burned. He still survived for 12 hours. It is very possible that he was found dead at this spot. But the story of oral dying declaration was introduced just to create some sort of evidence that he was alive. No oral dying declaration was made. But the CD could not support. He was at the verge of death at that time. Applicant Bridge Kishore Patel. Applicant Bridge Kishore Patel has preferred this application for suspension of sentence during pendency of CRA number 442 of 2014. The prayer for suspension of sentence has been declined on 16/4/2014 in IA number 2991 of 2014 and while order dated 20th September 2017 passed in IA number 13990 of 2016. As per prosecution case, the deceased made oral dying declaration before Kamlesh Prasad Lodhi, PW1, and Rajesh Kumar Lodhi, PW3, who are nephew and son-in-law of the deceased. The FIR came to be lodged on 25th September 2012 when with the allegation that at about 8 a.m. our local shepherd informed complainant in respect of deceased Lakshmi Din, who was lying in forest on account of burn injuries. On receiving the information from Kamlesh Prasad, Santosh, Rajesh, Mahesh, Ram Bhushan, and Ram Bhushan went there and found Lakshmi Din in injured condition. So, Kamlesh Prasad and Rajesh asked the deceased Lakshmi Din as to the person who said him who had injured him. The deceased told, the deceased disclosed the names of Bada Lalla alias Ramkesh and the applicant applicant. So thereafter, injured, with an injured oblique disease, Lakshmi Deen was removed to hospital and the doctor declared him brought dead. Kamlesh Lodhi also produced a CD prepared by the driver of the vehicle in which the complainant went to take the deceased Lakshmi Deen. So according to the rules of the CD was given to the investigating officer PW14 which as per the statement of the investigating officer PW14 investigator Ram Kirpal Singh PW14 he has admitted in his cross examination that the CD was not audible, but lip movements of the deceased were there. The deceased was having 90% burn injuries. And according to prosecution case, he has survived for more than 12 hours. When counsel for the applicant appealant submits that PW1 and PW3 are interested witnesses, PW2 has not supported the case of prosecution. The oral right declaration, the conviction on the basis of oral right declaration, in view of the facts, in view of the fact and circumstances of the present case, is not worth credence. There cannot be any dispute that the right declaration can be made, can be the sole basis of conviction. If it inspires confidence, the court should be satisfied that the deceased was in fit state of mind at the time of making dying declaration. And this statement is required to be independent, free from tutoring, prompting, and imaginary. Where the court is satisfied that the declaration is true and voluntary, it can base its conviction without any further corroboration. But the said rule cannot be an absolute rule of law. In the absence of necessary corroboration, when the dying declaration itself is suspicious, the same cannot be acted upon without corroborative evidence. In the present case, in view of medical condition of the deceased appearing in CD, he was not in a position to give any audible version, full stop. In such a situation, from oral right declaration made to PW1 and PW3, who are none else but the close relatives of the deceased, would remain debated, would remain debated. The applicant applicant has undergone 11 years and 7 months of actual sentence as on date. From State Council, our opposed the prayer on the ground that the applicant was lastly seen by KW11 Balmi in the shop of Bhayalal Kushwa at about 7:30 of 8 p.m. on 24th September 2012. And if the aforesaid last June version is read in conjunction with other attending circumstances of the case, the presence of the applicant is proved at the spot and he was having motive to kill the deceased. After hearing the motive of the parties, at this stage, without forming any opinion on the merits of the case, it would be just and appropriate to suspend the remaining sentence of the applicant subject